Okay, I'd like to call this meeting to order and welcome our witness for this afternoon, Cynthia Hines. Welcome.
Thank you.
And just to confirm that you've received a letter with information about a witness testifying before the committee?
Yes.
Okay, very well. And our clerk will have you swear an oath or affirmation.
Okay, so Ms. Hines, do you solemnly swear that the evidence you shall give to this committee touching the subject of the present inquiry shall be the truth, the whole truth, and nothing but the truth? So help you God?
I do.
Thank you.
Very well. And you have some time, about 6 minutes, for an opening statement, if you want to go ahead and
Thank you.
do that.
Good afternoon. My name is Cindy Hines. I'm a lawyer. I was called to the bar in Ontario in 1993. For most of my career, except for 8 months, I was an associate and then a partner at the international law firm Fasken Martineau Dumoulin. I was a member of the health law practice group at Fasken's and worked with hospitals, charities, and other clients in the health sector. In June 2011, I left Fasken's and went to work as general counsel at Ornge. Ornge has been a client of Fasken's since 2002. Fasken's was counsel to Sunnybrook Hospital at the time. As a result of that role, I received a call from Dr. Mazza, who was medical director of the Ontario Air Ambulance Base Hospital Program. The base hospital program was operated out of Sunnybrook. Dr. Mazza needed my assistance with a number of contract issues related to the base hospital program, which is regulated under the Ontario Ambulance Act. Commencing in 2003, Fasken's assigned me the role as billing lawyer for Ornge. This meant that I was responsible for the legal accounts rendered to Ornge, and all of the invoices were issued by me. This also meant that a majority of requests for legal work came to me from the executives at Ornge, and then a decision would be made as to whether other lawyers would do the work or I would do the work myself. This depended on the nature of the work and the expertise required, be it tax, banking, structuring, intellectual property, charities, privacy, government relations, or general corporate work. The lawyer who handled the particular piece of work would be known as the responsible lawyer for that work. In early 2007, Alfred Apps became involved in Ornge work. For the most part, he received his instructions directly from Dr. Mazza. He was the responsible lawyer for the legal work associated with the following: the financial statement consolidation, the Standard & Poor's rating, the 2009 bond transaction, the establishment of the Ornge Issuer Trust, the request for proposal, negotiation, and purchase of the Augusta Westland aircraft, the request for proposal, negotiation, and purchase of the Pilatus aircraft, the establishment of the Ornge Global Structure, the credit lease transaction, and the briefing of the government in January 2011 regarding the structuring of the for-profit businesses. I did not act as the first point of contact for these matters, but I did render the accounts for the work done on these matters. On 2 occasions, I was seconded to Ornge to assist it with legal matters. The first secondment was in February 2005 to help with the divestment of the air ambulance program from the government. There was a great deal of legal work expected, and I was seconded to Ornge at a flat rate to minimize costs. I spent approximately 6 months at Ornge before returning to Fasken's in September 2005. During that secondment, I worked with a team from Ornge and a representative from the government conducting due diligence on contracts being assigned to Ornge and assets being transferred to Ornge by the ministry. I also helped draft and negotiate the performance agreement. The second secondment occurred in November 2009. Through to June 2010, Dr. Mazza approached me about the secondment because his in-house legal counsel at the time was on sick leave. I spent approximately 15 hours a week at Ornge providing general counsel services, primarily contract drafting. On June 14, 2011, I started as general counsel at Ornge after I resigned from Fasken's. During my time at Ornge, I worked on various matters for the Ontario business, including the internalization of the rotor wing services, as well as the following for the international businesses, a joint venture with Synergy Group out of Brazil, the AirMed transaction, the second marketing services agreement with Augusta Westland. This was known as the Joint Global Marketing Services Agreement and was between Orange and Augusta Westland in Italy. A letter of intent with Bombardier, and the 2011 offering memorandum for potential third-party investors in Orange Global Limited Partnership. I was not involved in the M&P report, which was commissioned by the Ministry of Health in 2008, nor was I involved in providing information directly to the Auditor General's office. With regard to the transactions involving Augusta Aerospace Corporation out of Pennsylvania, I did not provide legal advice regarding the aircraft purchase agreement dated March 27, 2008. While I did provide legal advice to Maria Ronzella and others at Orange regarding the terms of Amendments 2, 3, and 4 to the aircraft purchase agreement, I was not involved in negotiating the technical or financial terms of those amendments. At all times, I believed that Orange Issuer Trust paid fair market value for the upgrades to the helicopters. When I was a lawyer at Faskins, our advice was that Orange Issuer Trust could not pay more than fair market value for any purchases from Augusta Aerospace. Management repeatedly assured us as counsel that they understood our advice and that they were paying fair market value for the upgrades. I was also involved in providing legal advice to Orange regarding the first marketing services agreement, the one between Augusta Aerospace and Orange Peel. At all times, I understood that the financial terms of the agreement were negotiated at arm's length between the parties. I have brought some documents that may assist the committee in understanding the advice Faskins gave relating to the agreements involving Augusta Aerospace. I always also brought copies of my statement for the committee. I am no longer employed at either Orange or Faskins. I'm happy to now take your questions.
Thank you for your statement, and the NDP will have the first opportunity to ask questions, and so you have 20 minutes to ask questions. And who would like to go first?
I guess I'll go first.
Okay.
Thank you for coming today. I guess that, like everybody else, you read the papers, and I'm just wondering if you have been following what has been happening with this committee, if you've read any of the briefing, if you read the Auditor General report.
With respect to the Auditor General report, I had left Orange after, I'd left Orange and then the Auditor General report came out after that. I haven't had a chance to read the report in great detail. I did read the summary of the Auditor General's report.
Okay. All right. In your statement you just read today into the record, you make a point of saying that you worked on the second marketing agreement, that your work on the second marketing agreement was different from the advice that you provided on the first marketing agreement. Can you expand a little bit as to what you had to do with both of them and how they were different and how they came to be?
The first marketing, we're talking both marketing services agreements? Okay,
correct.
So the first marketing service agreement, I was asked to look at a few legal issues and document the deal that was negotiated between the parties. I was not involved in any of the negotiations on the first marketing services agreement. Rick Potter, he dealt with all of the negotiations on the technical aspects, the operations. Maria Ronzella, she dealt with Augusta on all of the financial issues. So Mr. Potter indicated what he needed operationally. She negotiated the finances of that. And then they asked me to document the negotiation that they had, the arrangements between them and Augusta. On the second agreement, I had just started back at Ornge. I just started at Ornge in June, and July, Dr. Mazza and 2 other people had gone to Italy and came back with a draft agreement. And they, I think what they had done was used the template for the very first one. So the first agreement was with the Pennsylvania Corporation. The second one was with the Italian corporation. I think the Italian corporation was the parent of the Pennsylvania Corporation. So they had gone to Italy and negotiated an agreement. And I think what they had done was they took the first agreement and used it as a template. They came back and said, the deal has been done. There are just a few legal issues that we need you to review. And one of them was, what happens in the event where there's a disagreement, so arbitration. The other issue had to deal with jurisdiction. So if there was some sort of a disagreement, what jurisdiction, what law would take precedent? Would it be the Italian or would it be Ontario law? So there were just a few legal issues that they had wanted me to look at, and then I was involved in speaking to counsel in Italy and trying to get those resolved.
You stated that, okay, we'll take them one at a time. During the first agreement, you were looking at a few legal issues of the document, of the deal that was done with Pennsylvania. Did you, now that you've read the papers, when did you become aware as to where the money was coming from?
For the first agreement?
Correct.
For the first agreement, we always thought, and when I say we, the lawyers at Faskins understood that marketing agreement was a separate arm's length transaction because of the advice that we had given them when they first came to us. I'd like to refer you, if I may, to tab 2 of the document that the binder that we had just handed out.
Yep.
So when we were asked for some advice, it's important to note that at that time, and you'll see it's January 15th, 2010, we were told that there was penalty payments that were owed to the trust because some of the aircraft was late. There were delays, and they hadn't met the timelines. And in tab 1 in this binder, we had just put in certain pages for the aircraft purchase agreement, and you'll see under tab 1 there's a provision that talks about inexcusable delay. It's paragraph 5.5. And if you see there, it says what happens when there is a delay, and there's a maximum penalty of $160,000 per aircraft. So at the time, what we had understood was there had been delays, and they had penalties that were owing. And then there were also some credits. So they had come to us and asked us if they could take that money and have Augusta Westland pay it over to the foundation so that they could use that for their other ventures. And if you see here in this email from Lynn Golding to myself, yes, tab 2, we set out very clearly our advice to them, which was that they couldn't take the money, be it the credits or any of the penalties, and give it over to another corporation. If you do that, you're depriving the trust of value, right? That's for the trust, right? Those assets, the bondholders had made investments into that trust. You cannot do that. You have to keep whatever you're doing completely separate. right? So we made it very clear to them that they would have to, if they didn't want the cash, then they would have to use that money, and the penalties and the credits could be used as a set-off then for any upgrades that they were going to receive. But we made it very clear to them that OIT was to get the full benefit of the credits and the penalties. And so if you look at Ms. Golding's email to me, and what you need to understand is what I did with this when I got it. When I got this email, it was part of the time when I was working 15 hours at Ornge, and Ms. Renzella was away at school, and so I sent this to my Ornge email account, and then I forwarded it, when she got back, I forwarded it to her, and then she and I sat down with this document and went through it very carefully, she and I. And then when I didn't know if she absolutely understood what I was saying.
Like us.
Pardon?
Like us.
You don't understand what I'm saying?
Having a hard time.
Oh.
But go ahead, sir.
Sorry. I'm trying to explain.
Let the witness, please don't interrupt the witness. Go ahead.
So when what I did was I said, I then printed this out, and I sat down with Ms. Renzella, and we went through it, and then we called Ms. Golding, and I had Ms. Golding explain it again, so that Ms. Renzella understood exactly what it is that we were trying to say. So if you look at, I don't know if you want me to read this, but I will just point out to you, in particular, paragraph 1, it said, "It is important that the arrangements with Augusta and the Foundation not deprive the trust of assets or value that it would otherwise be entitled to. If the arrangements did deprive the trust of value, and the trust in the future found itself in default to the bondholders could have recourse to those who authorized these transactions, among others. To be sure that the transactions do not deprive the trust of value, the following two things should occur. The trust should receive upgrades with a minimum fair market value equal to 1.92, for which it pays nothing. That's $1,920,000. Now again, at that time we thought that all 12 helicopters were going to be delayed, and they would be facing Augusta would be paying $160,000 penalty. That was not the case at the time, but that was our understanding as we were writing this email. And the trust should not pay more than fair market value for the upgrades it's required to pay, whether by paying with new cash or applying the credit note it has already bargained for. In order to be certain that this is the case, Ornge needs confirmation of the fair market value of the upgrades. This is likely not the list price. A proxy for fair market value may be the list price less the same discount rate that Ornge was able to negotiate when it struck the original deal." And then she goes on to say, "If I have stated the minimum fair market value of the free upgrades at $1.92 million rather than $400,000, because I understand that it was not for the amendments now being negotiated, Augusta would ultimately be required to pay a penalty of $1.92 million. So that is the amount that the trust is giving up by agreeing to enter into the amendments. It's true that arm's-length parties will sometimes waive such fees without getting full value for doing so. The trust could do so in the case, too, if it is considered to be commercially reasonable, but not where there is also a contemplation of a gift being made to the Foundation or another Ornge entity." And then she goes on paragraph 4.
Okay, so you know full well what they had intention to do with the money, because it become clear that the advice is being given because they understand that Ornge is about to take money that should be coming to the trust, and they want to pursue their other venture, their international venture, so they want to bring that money under a different corporation. Your advice is that you shouldn't be doing this because you are depriving the trust of value. If you are to do this, basically here are the two things that needs to occur. So everybody knows full well what they have intention to do, and everybody knows full well that what they had intention to do actually happens, because the money does get transferred and the marketing agreement does get written up.
No, that's not what I'm saying. That's not what we knew. What we knew was that they wanted to take this money that from the upgrades and, the credits and the penalties, give it to the foundation. We said you cannot do that, whether it's the foundation or any other one of those Ornge entities. You cannot take from Peter to pay Paul.
I fully understand that you told them that they could not,
yes.
But you knew what they had intention to do because you told them, no, you cannot do this.
Right.
And you also know what they actually did with your advice, which is, thank you for your advice, but we're going to move ahead with what we had intention to do anyway.
No, they told us that what they had done, they constantly assured us. When
Who is they?
I was dealing at the time with Maria Renzella. So I was told in no uncertain terms several times that she understood our advice and that she was speaking to Augusta Westland to get the fair market value of the upgrades. And when I asked her, because this process took quite a few months, and I didn't quite understand why it was taking so long. They were going back and forth with numbers, and she said she was working on getting the fair market values. I said, make sure you get them in writing. You should find out what other people are paying for these upgrades. So at all times, we understood that they were paying fair market value for those upgrades.
Okay. And you understood this because Maria told you?
Several times.
Okay, so there are information that comes to you in the way of Maria talking to you. There are also information that comes to you. You have eyes. You can see that what they had intention to do is what actually happened. I fail to see. How come I can see this but you can't?
What information is coming to me?
The information, you're just telling me that Maria fully understands your advice, and your advice is that you're not allowed to do this.
Yes.
Maria fully understands, and she tells you that she fully understands that they're not allowed to do this, but they go ahead and do it anyway.
They didn't go ahead and do it anyway. What they had did, they went and they did a services agreement, which was contemplated by the original purchasing and sale agreement. And they entered into what we thought was a separate arm's length transaction. And as long as they were paying fair market value for those upgrades, this was a separate transaction with the marketing services agreement. Augusta, they were arm's length parties, and Augusta could pay whatever they wanted for these services. I was told that they were going to be they were going to be doing this research because they were doing this new business. They were hiring people at the time, and that Augusta wanted to enter into a new market. They were entering into a transport medicine market, right? And they thought that Ornge could
Sitting
assist
here,
them.
it looks like you drank the Kool-Aid. Like, they are telling you that this is what they want to do with this money. You tell them you're not allowed to do this. It is illegal. They come back with this marketing agreement, which Ornge has never been into, has never provided. He hired his girlfriend to do the work and the daughter of another executive of Ornge to do the work. And you think that everything is just fine, that they are following the letter of the law.
I had no indication that anything was amiss. And if I had any indication that something was amiss, I would have gone to my managing partner. I would have gone to the board. And if they still wanted to proceed, we would have withdrawn. I can assure you that there was no way I would put my reputation, my family, at risk for this.
Do you feel that your reputation is at risk now?
Absolutely.
What went wrong?
What went wrong? He,
Mr.
being
Mazza?
Dr. Mazza, wanted too much, too fast. He was very bright. He was a visionary. I really believe that Dr. Mazza's primary motivation was to have a world-class system in Ontario. He wanted to expand it globally. He got ahead of himself. In the process of creating this vision, he made a lot of enemies. Right? I think he forgot the stakeholders, and he made a lot of enemies. And within that corporate office, there was a lot of fear. So it was a combination of things. And there are a lot of people who are suffering as a result.
You're one of
Do you
them.
want to take a couple minutes to compose yourself? Okay, we'll take a 2-minute recess. Okay, we're back in session. You have a minute and a half left in this round,
Okay.
Ms. Jelonis.
I have a minute and a half left. The questions will come to me again. You were one of the person who got hurt in this, I will call it the fiasco at Ornge. When did you realize that you were at risk, your good reputation, your family, your integrity was at risk?
Labor Day, the day after Labor Day, when the CTV story came out from Paul Bliss. I had taken the day off to get my kids ready to go back to school, and I had received a call to watch the television. And that was the first time I had heard about the kickbacks and all of the operational issues that were going on. I had no idea about, the problems with the interiors of the aircraft. So I think it was at that point in time that I got worried when I heard the interview or the investigation of Paul Bliss.
So when did you leave Ornge?
It was February 16th this year.
This year. Okay.
Thank you, and we'll move on to the to the government. Who would like to ask questions, sir?
Yes.
Ms. Sandals.
Yes, thank you very much, and thank you for appearing here for us today. And I'm going to give you a packet of documents. Earlier this week, we received the billings, a copy of Fasken Martineau's billing statements for the legal services provided to Ornge and its related entities. And obviously, when you look at that it's clear, as you said, that you were one of the lead lawyers at Fasken's on the Ornge file. Right back to January 2003. That's actually, you mentioned that Fasken's began acting for Ornge in 2002, but in fact the first thing that we see is what I've given you here, which is starting back in January 2003. But what you're seeing there would reflect the work that your firm billed for in 2003. And so it would appear that, at least from the billings we've seen, and you indicated they might go back further, but at least from the billings that we've had access to, that Fasken's was doing work on this file, and you personally were doing work on this file during 2003 for certainly the 9 months in 2003 prior to the October election. So during the time of when Premier Eves was the Premier of Ontario, so during the Conservative government. And during that time, Tony Clement was the Minister of Health, correct?
Yes.
Yes. And could you then explain to us during this period, during 2003, January through early October 2003, what position you held at Fasken's at the time?
I think I was. You mean, was I an associate or a partner?
Yeah,
or is that what you mean?
and particularly with respect to this file. So both those. What position did you hold in the firm, and what position with respect to this file?
I think I had just. I was an associate, and I think I had just become a non-equity partner in maybe February or March of that year. It was either that year or the following year. And with respect to on this file, the file had just come in 2002. It was brand new to the firm, and but I think in 2003 they had switched over, opened up a new file. Instead of Sunnybrook, it was now Ontario Air Ambulance. And they assigned me the role of billing lawyer because I had probably most of the contact initially with Jacob Bloom and a few others at Ornge.
Okay, that's fine. Yeah. And given your position as a new non-equity partner, you would have reported to a more senior partner?
Well, what we did is we have a group. It's our health law group, and
who headed that?
Lynn Golding.
Okay.
And so, she, I would talk to her about things that were happening, and there were other, people, other more senior people in the group, and so,
okay.
it wasn't like a reporting sort of a reporting, but it was, we all worked together, and, you always asked.
She
for
would have been
advice.
one of the more senior partners in the group. Thank you.
Yes.
And I'd like to go back to thinking about just in 2003, because you're quite familiar with the file. How was Ontario's air ambulance service organized at the time? When you started to work with OAA or Ornge, whichever you want to call it, how was it organized at that time?
My understanding from what I had learned from Jacob, and mainly from Jacob, was that he referred to it as a siloed system. So there were many different entities providing the service, but there was no real one line of accountability. So at that particular time, and I am going from memory, I think at that particular time, the pilots and the medics were employed by the air providers. The dispatch was employed by the ministry. The base hospital was under Sunnybrook. Who am I missing? The medics, the pilots, the dispatch. I think another area of the ministry was doing all of the billings.
Okay.
Right? So there were a number of different players involved at that time.
And what becomes clear when you look at the early dockets is that Faskens seems to be hard at work addressing the issue of building a new corporate structure. There's a lot of conversation about corporate structure for air ambulance services. Is that correct?
Because they wanted to be their own entity. They were a program or a division of Sunnybrook and Women's. So at that time, they were looking to try and determine what the best structure would be for them.
Okay, and Faskens is involved in that. So why would it be Faskens that was busy sort of designing and working on what should the new corporate structure be and not the Ministry of Health?
Well, the Ministry of Health wasn't, I can't speak to that, but the Ministry of Health wasn't our client. It was this Ontario Air Ambulance that came to us. I think that what they were trying to do was have a few options so that they could present to the ministry to see to get them on side and see which option that they would prefer.
So they're having Faskens explore the possibility of various corporate structures. At this point, then, are you aware of what was the preferred corporate structure that Dr. Mazza said you were trying to get to?
No, I was mainly dealing with Mr. Bloom.
How would he have expressed where you were trying to get then?
Well, it really wasn't. It was what we were looking at that point in time was, would it be a crown? Like there were other structures that were being looked at. Would it be a crown corporation? Would it be a not-for-profit? Would it be a charity? And I recall having conversations with Mr. Bloom about a crown corporation, and see what he was doing is we were providing him with the advice. He was liaising with the ministry, and I remember him coming back and saying they've settled on a not-for-profit corporation.
Okay, which leads perfectly into my next question. If you could look at the docket on page 1, dated January 14th, 2003, and this is actually the docket of Alina Hofstein. Mm-hmm. And the description of the time card there is meet with Cindy Hines to discuss compensation of directors and funding activities of the corporation. So firstly, do you recall what issues were in play when you were talking about director compensation? What does that refer to?
Well,
what was the issue?
The issue was if you were looking at a not-for-profit or a charity, right, then there are certain rules about whether directors of charities could could be paid for their time as directors, and
why would that be an issue?
I believe they wanted to be able to pay their directors remuneration for the time that they were going to be spending on on work.
So at that point, were there already particular people that they had in mind to appoint as directors? Or particular
2003?
compensation levels?
No, I don't recall. I don't recall that. We're fairly new at this point. We're more or less just looking at different kinds of corporations. For profit, not for profit, charity, non-charity.
So, are you aware that eventually it has come out that Rainer Beltzner, who did become the chair of a nonprofit corporation, was being paid $200,000 a year?
Yes, I heard that. I was not aware of that at the time.
Because
I knew Mr. Beltzner was being paid something.
Given your advice that he could be paid?
Well, it was advice that we had done a very lengthy memo to them on director compensation, and I don't have it, but it was authored by Ms. Golding, and it basically said that the amount of money to be paid to directors of not-for-profits and charities should be very slim. It's not a lot of money, and so it would be more akin to a per diem that the local integration health network directors would be receiving.
And then the other part of this is the funding activities of the corporation. Now, what on earth were they contemplating when they asked you to look early on in the game here at funding activities for this corporation?
As far as I can recall, they had always had in their mind that they wanted to be able to get donations from the patients and the family of patients, the patients that they helped. They had, when Jacob had initially come to Faskins, he talked about this model that was out west. It was the STARS model, and how everyone in Alberta, I think it was, felt that they owned this air ambulance system. And there was an issue that Ontarians didn't appreciate that the government provided this service, and they wanted the people of Ontario to feel proud of the service and want to donate to the service.
But as early as January of 2003, Jacob and presumably Dr. Mazza were already thinking about sources of funding other than transfer payments from the government.
Yeah, I believe that they had gone, that was one of the things that they went to the ministry and said, if we do this, then we can have a foundation like a hospital foundation. We can get other revenues from the foundation, which would lessen the burden of the ministry. That was the theory at the time.
Okay, could you look at page 2 on a docket dated January the 17th? This is one of your dockets, about the middle of the page. It says in part, conference call with C. Mazza, J. Bloom, and E. Hoffstein, Rice, structure of new corporation and utility of separate foundations. So what was that related to? Again, why at this point thinking about setting up separate entities?
I don't know if I can elaborate much more other than they were looking at other ways to generate revenue and to get more revenues into the program. So they were thinking about how to generate more revenue. Same page 2, dated January the 20th. Again, I have one of your dockets, and you've got meeting with Alina Hoffstein, restructure of new corporation. What happened there? Anything? Any other? No, nothing's of significance.
So carrying on with
coming.
the same.
Yeah, I think we're continuing on with the same conversations. I'm not recalling anything
Okay.
different or significant.
Okay, so back at this time you're doing this work, was there any contemplation at this time that this new corporate entity would have spin-off entities? Were you thinking that this new for-profit would somehow have spin-off entities at this point?
In 2003, I don't think so.
Could you look at page 3 then, January 22, this one's Lynn Golding, and she references a meeting with Cindy Hines and Guy Giorno, Ray, the structure of spin-off entity.
Mm-hmm.
So, like, this sounds to me like there is a conversation about what are the spin-off entities to this corporate structure.
No, the spin-off entity is the spin-off from Sunnybrook. From the way I'm reading this and just knowing what was transpiring at the time, it's the spin-off from Sunnybrook, the program, into a new corporation. Okay. It's not, we already have the corporation and we're looking at, we don't even have a corporation in 2003, so a separate corporation yet. That Ontario Air Ambulance Services Company wasn't incorporated until 2004.
Okay, and so when you look at these dockets up until, from January 2003 up until October, what you actually do see is that Fasken has logged an incredible amount of time. There's 30 pages of dockets that I've given you there during that time. Looks like over 600 hours were logged. Who was paying for this? Like, how was it wasn't being billed to Ornge? Who were you actually billing?
In 2003?
Yeah.
We were I think we were billing the program. I don't think we were billing Sunnybrook per se anymore, but we were billing the program.
And who funded the program?
The ministry.
So the ministry is funding the air ambulance program at Sunnybrook,
yes,
to provide the air ambulance base hospital, but yes, the money that the ministry is providing to fund the base hospital is then going on to Fasken's to do all this legal work to set up something or do something.
That's my understanding.
So the Ministry of Health was indirectly paying Fasken's. The other thing that stands out when I look at all of this is that there's a number of individuals that obviously have very high-profile conservative connections at this point. We've got Guy Giorno, Jacob Bloom, Kevin McCarthy. So it is also quite clear from the dockets that you're not just doing contract work, you're also doing lobbying or government relations. There's all kinds of references to government relations. So
I believe Mr. Journo and Mr. McCarthy registered as lobbyists at that time. That was my understanding, that Mr. Journo and both Mr. Journo and Mr. McCarthy did register as lobbyists in 2003.
So the Ministry of Health thinks it's paying for air ambulance services, but part of what was going for air ambulance base hospital services is not only going to Fasken's to do contract work, it's also going to Fasken's to do government relations and lobbying work, to lobby the same government that is paying for this to set up a structure that Dr. Mazza wants. Do you see anything circular about this arrangement?
I see it circular the way you describe it. I can't confirm that's the way it happened. I think it did happen that way. The best thing to do would be to ask somebody in the finance department at Ornge as to how they paid for those bills at that time. I don't want to speculate, but
Because I must say, looking back on this, is it possible that the firm, so we've got Ms. Golding, who's obviously the wife of the Minister of Health, we've got Mr. Giorno, who used to be the Chief of Staff to Premier Harris, and we've got this lobbying, and there seems to be this financial opportunity. How can we create more revenue? You've got to admit that this is a very suspicious-looking organization that we're looking at here.
30 seconds left.
It was, from our understanding, it was all for to improve the system. You have to recall that my understanding there was a report that said that the system was fragmented. There was a coroner's inquest that said that there were problems within the system, and so they were trying to make the system a better system, which is what I believe the primary motivation was. So,
thank you, and we'll move on to the opposition. Mr. Klees.
Thank you, Mr. Chair. Ms. Hines, we have a serious issue here, and that relates to the total contradiction between what we're hearing from you today with regard to your understanding of the marketing services agreement and the very clear testimony of three other witnesses before this committee. Have you read the testimonies of Mr. Rothfels and Mr. Potter?
yes.
And you will be aware that both individuals who were very intimately involved with the negotiations with Augusta related to this marketing services agreement, both were very familiar with the details, and both have contradicted your testimony today. You're aware of that?
I do not agree with Mr. Potter's testimony, nor do I agree with Mr. Rothfeld's testimony, and I'm happy to elaborate.
Okay, let's deal with this line by line then. Mr. Rothfels testified that he became very concerned about the agreement that was taking place between Ornge and Augusta regarding the payment of $600,000 per aircraft. And he indicated that it was his understanding that Maria Renzella and yourself were primarily responsible. I'm actually quoting from his testimony. He states that both Maria Renzella and Cindy Hines were primarily responsible for carrying out the directive that they got from Chris to come up with a marketing services agreement. Do you agree with that statement?
No, I've never spoken to Dr. Mazza about this agreement until, I should say, I only spoke to Dr. Mazza about this agreement in August of 2010 when Maria was on vacation and he wanted to know why it hadn't been signed yet. I never received any instructions. I've never had any conversations with Dr. Mazza about this agreement.
Mr. Rothfels goes on to say, and again I quote from his testimony, which he gave under oath, "Yes, I think I reiterated a number of times to Rick Potter, to Cindy Hines, to Maria Renzella, and to Chris+mazza that the $600,000 weight upgrade was a fictional charge and that we, Ornge, should not be paying it." Do you disagree with that?
Mr. Potter, I don't know, number one, what Mr. Potter told Maria.
No, this is Mr. Rothfels.
Oh, sorry. I don't know what Mr. Rothfels told Ms. Renzella or Mr. Potter. Mr. Rothfels was in my office talking about various things and mentioned the marketing services agreement.
And what did he say specifically about the marketing services agreement?
He said, you and Maria are being set up to take the fall. And I said, what in the world are you talking about? Those agreements are separate from the upgrades, and I've been assured that they are paying fair market value for the upgrades. And I then went to Ms. Renzella, and I said, very upset, and said, what is he talking about? And I said, and she said she didn't know. And then she said, and I said, are you paying fair market value for those upgrades? Yes. Did you receive that in writing from Augusta? Yes. Are you confident that you're receiving all the upgrades for fair market value? Yes. Shortly thereafter, I think Mr. Rothfels left the company, and I had no opportunity to speak to him again. That was the only thing that Mr. Rothfels said. I took it straight to management to find out, and again, I was assured that they understood our advice and that they weren't paying any more for the upgrades. He didn't tie it at that time or any time to the weight upgrade.
So you're admitting that the amount related to the marketing services agreement was tied directly to the issue of the upgrades, is that right?
No.
But you just said, you just referred to the upgrades.
I referred to the upgrades because what else could he be possibly talking about?
Well, he could be talking about what you were talking about in your earlier testimony. You made no reference in your statement to upgrades at all. You gave us a scenario that had to do with helicopters being delivered late.
But there were upgrades within that.
No. Fine. I'm just simply saying that you now are agreeing that the amount that was related to this marketing services agreement had to do with the upgrades, as it has been discussed by Mr. Potter as well as Mr. Rothfels. Is that right?
No, that's not. That's not what I'm saying.
Okay. Let's move on to Mr. Potter then. Mr. Potter testified here, and with reference to the amount that was to be paid through this marketing agreement, he said, and I quote again from Hansard, I said, and this is Rick Potter advising Dr. Mazza, I said there is no value in this. This is paper. There was no material change to the aircraft. And he said, well, there are other things to be considered, or something to that effect. I'm not quoting, I'm paraphrasing, okay? And that was that. I said to Mr. Potter, and the bottom line is he directed that Ornge should pay that additional amount. And Mr. Potter said, not to me, he didn't, sir. My response was, who would he have directed? Mr. Potter's response was, I know that Maria Renzella came in shortly thereafter and said, there has to be a value to this. I said, there's absolutely none. And I told her the same story. He goes on to then talk about the fact that you, as the lawyer, were given direction to draft up the documentation related to this, what would end up being a marketing services agreement. And again, I quote Mr. Potter from Hansard. I talked to Cynthia Hines, and I said, look, this is nuts. This is not a secret. He's referring to the fact that there is no value. He goes on to say, what I had done when I came back was share it with our committee, that is his negotiating committee, because we had a list of ongoing challenges with Augusta we were trying to solve and say, we can strike this off the list. This is off the list, and this is off the list. There were a number of people who were well aware of that. In fact, I reported to the Executive Committee what had happened that time. I said, this doesn't make any sense to me. So that was Mr. Potter's testimony. He also advised us that as the in-house lawyer, you're someone who, as a matter of rule, would draft agreements. And we were told that the final, or all of the drafts of this marketing services agreement were drafted by you. Is that correct?
Yes.
We're also told that there were some early drafts of the agreement that were discarded. Do you have copies of those earlier agreements?
I don't have any copies of the agreements.
Would they be on file at Ornge? Would those records have been kept?
They would be on file at Ornge. Maybe Faskins would have them. I don't have them.
Okay. I would like us to see if we can get, Mr. Chair, the first drafts of the marketing services agreement that may be in possession that were drafted by Ms. Hines. And the reason I'm very interested in those agreements is that we have been told that those early agreements, the reason that they were discarded is that they were very transparent in terms of what the money flow was and that there really wasn't any value to them. You have any recollection of that?
None.
Okay.
But I would like to, because that was, if you don't mind, I would like to address a few things that you said. First about Mr. Rothfels, and then about Mr. Potter, if I may. Mr. Rothfels also said in his testimony that you did not have to pay for the weight upgrade. The weight upgrade was already included in the aircraft purchase agreement. Now, if you look at the pages from the aircraft purchase agreement, it's under tab 1. There are a number of schedules, and the most important schedule is Schedule 1. It's toward the back, and there's page 5 at the back, and it says additional equipment list, optional equipment. And you can peruse through Schedule 1, and that basically, it's entitled Helicopter Configuration and Weight Analysis. There's nothing in Schedule 1 that talks about a weight upgrade. And
could I just, I don't mean to interrupt you. We will have time to come back at this again.
But
in
I
the
think
next
these
round.
are very important points,
And I will
sir.
let you make them. I just have to deal with a matter of business here.
Please let the witness please answer the question.
So when I drafted the Amendment 3 to add the weight upgrade, thank you, Mr. Chair, when I added the weight upgrade, if you look on tab 3, there was number 2 on Amendment 3. It says, delete the life rafts on that Schedule 1 and substitute the following: MTOW 6,800 kilogram upgrade. That was the addition of the weight upgrade. It had not been provided for in the Agreement of Purchase and Sale. It was not in there. I added that. With respect to Mr. Potter's recollection, Mr. Potter and I were drafting the amendments to the agreements. I was drafting Amendment 3, and we met because he came to me. We were going through the technical requirements of that amendment, and said to me, I negotiated a better deal. And I said, what do you mean? He said, well, I got a lower price. And I said, well, do you have that in writing? Is there anything in writing? Is there any documentation that can corroborate that? To which he said, no. I went to Ms. Renzella and I said, Maria, Potter says he negotiated a better deal. Can you look into that? She came back and she said, there's no other deal. For the next 4 months, I continued to send amendments to Mr. Potter. Mr. Potter commented on every single draft of the amendment. He never mentioned another thing to me after that point. And in tab 3, you will see emails where Mr. Potter signed off on that final agreement, as did Ms. Renzella and the other people at Augusta Westland. So Mr. Potter's memory, I think, is failing in this instance.
I think we have
5.5 minutes.
I think we have a lot of memories that are failing. But Mr. Chair, I'd like to deal with a matter of business, if I could.
You have the floor.
Today, during question period at the Standing Committee on Public Accounts, it was evident that the member for Willowdale engaged in a case of witness tampering, and as such, I feel that we should report this issue immediately to the House. Parliamentary authority says that witnesses appearing before committees enjoy the same freedom of speech and protection from arrest and molestation as do members of Parliament. Mr. Zimmer's questioning could not have infringed on this principle more. Mr. Zimmer said this, and I quote, "When you're faced with this choice between what's doing best for the air ambulance service and fixing it and getting to the bottom of it, and yet you don't want to share some of that confidential information and confidential names who might help us with that, and you opt to protect your source," Zimmer said, "do you think that's a bit selfish of you?" He continued, Mr. Chair, by stating, and I quote, "And their careers trump the safety of Ontarians. They'd rather protect their careers than help us root out the causes of difficulties at Ornge." Mr. Chair, it's evident that Mr. Zimmer's questioning is an attempt to intimidate Mr. Kidd in an effort to deter the witness and any further witnesses from testifying. O'Brien and Bosch state that tampering with a witness or in any way attempting to defer a witness from giving evidence may constitute a breach of parliamentary privilege. Similarly, any interference with or threats against witnesses who have already testified may be treated as a breach of privilege by the House. O'Brien and Bosch also state that, and I quote, "In a ruling given on February 20th, 1984, the Speaker stated, 'A threat emanating from any government department or public corporation to withhold information or cooperation from a member of Parliament would undoubtedly hinder that member in the fulfillment of his or her parliamentary duties and therefore constitute a breach of privilege,' end of quote. O'Brien and Bosch also cite a case from 1992 where, and I quote, "A witness who had testified before a subcommittee was advised by a Crown Corporation employee that the issue of her testimony was being referred to the corporation's legal department. The witness informed one of the committee members who raised a question of privilege in the House. Speaker Fraser ruled that the matter was a prima facie case of contempt. When the Committee on House Management reported back to the House on the question of privilege, they reaffirmed that, and I quote, "The protection of a witness is a fundamental aspect of the privilege that extends to parliamentary proceedings and those persons who participate in them," end of quote.
Point of order.
Australian parliamentary guidelines further clarify
Mr. Klees has the floor.
that, quote, "Section 12, bracket 1 of the Parliamentary Privileges Act 1987 prohibits a person from using various means, including threat, intimidation, or inducement to influence another person in respect of evidence to be given before a House or a committee." Furthermore, former MP and lawyer Derek Lee states, and I quote, "that obstructing or tampering with a witness is a breach of privilege of the House or of its committees who have the delegated authority," end of quote. These tactics fit a pattern of fear that has been exemplified by witnesses who have been already in front of the Public Accounts Committee. This begs the question, what other witnesses have been threatened or tampered with or intimidated? I conclude with a ruling from former Speaker of the House of Commons, the Honourable Jean Sauvé. Speaker Sauvé ruled that, quote, "When new ways are found to interfere with our proceedings, so too will the House, in appropriate cases, be able to find that a contempt of the House has occurred," end of quote. Mr. Chair, I'm prepared to move an appropriate motion for the committee to report on this matter back to the Speaker of the Legislature.
And, Mr.
Thank you.
Klees, at this point, I will cut you off. I have the floor, and I would like to inform the committee that the chair has no authority to rule that a breach of privilege or contempt has occurred. The role of the chair in such instances is to determine whether the matter raised does in fact touch on privilege and is not a point of order, a grievance, or a matter of debate. This morning's questioning, witnesses come before this committee. The members have an opportunity to ask questions. I did follow the questions very carefully. Mr. Zimmer was asking questions, and the witness was providing answers. I followed it closely, and I saw nothing wrong with that. So we shall move on now, please. I have made my ruling. And you have 30 seconds left, Mr. Klees.
Well, in my 30 seconds, Chair, I will simply say this, that I can tell you if witnesses who are observing these proceedings see the kind of conduct and the kind of attitude that Mr. Zimmer portrays here, I would not want to be a witness coming forward. I think it's unconscionable behavior, and I would simply hope that Mr. Zimmer will take note.
And thank you, and we shall move on to the NDP. And who would like to ask questions there? Mr. Singh.
Thank you very much. Good afternoon, Ms. Hines. Ms. Hines, I want to ask you some questions surrounding any connections or any conversations you had with the ministry. In your involvement, both as outsourced counsel with Faskins and when you were with Ornge directly as in-house counsel, did you have any meetings or interaction with ministry individuals?
I had the only contact that I had with ministry people were the people from the legal branch.
Okay.
So that was when we were working on the performance agreement with Mr. Springman.
Okay.
And he had a few other people from his branch working on that. I then had occasion over the years to speak to Mr. Springman about questions about the performance agreement.
Sure.
I think he had a junior, Mr. Georges, Bill Georges. I might have spoken to Bill a couple of times about the performance agreement, but nobody else from the ministry.
Okay. And these individuals from the legal department, would they have been with the Ministry of the Attorney General then?
No, I don't. That doesn't ring a bell.
You think they were with the Ministry of Health, but the legal
services branch
of the Ministry of
Health.
I understand.
There was a meeting with somebody from the Ministry of the Attorney General.
Yes.
Back in December of 2009. There was a meeting with Mel Springman at our firm, Bill Georges, and someone by the name of Kevin McGuinness from the Ministry of the Attorney General, I believe. And they wanted to speak to us about the bond transaction. And they wanted to learn more about the bond transaction, and Mr. Apps explained it to them.
Okay. And just to break down some of those meetings, in the meeting with, you indicated Mr. Springman, and he had a junior, Mr. Georges?
Yes, at that particular meeting.
At that particular meeting. Mm-hmm. And those are individuals from the legal services, from the government side at least. If you're not sure exactly what division, you think it was the legal services branch of the Ministry of Health.
That's right.
But it may have been just from the ministry in general, or from the government side in general.
I'm pretty sure they said it was the legal services branch of the
That's
Ministry
fair.
of Health.
And who was present on your end in terms of on Orange's behalf?
At that particular meeting?
At that particular meeting, yes.
That was Alfred Apps was there.
Yes.
Myself, Maria Renzella.
Yes.
From Orange. Someone by the name of Scott. He was a government relations person.
Sure.
From Orange.
From Orange side. And when was that meeting? That meeting specifically with Mr. Springman and Mr. Georges?
That was sometime in December of 2009.
2009, okay. Mm-hmm. And in that meeting, can you recall what the contents of? I mean, specifically, you said it was related to the performance agreement. But what about the performance?
Not in 2009.
No, okay.
In 2009, it was to deal with the bond transaction.
Okay. And was it limited to the bond transaction, or was there anything else?
It was pretty sure it was limited to the bond transaction.
Okay. And when did you have meetings regarding the performance agreement?
Oh, that was at the very beginning when we were actually drafting and negotiating the performance agreement.
Okay.
But once we had drafted the performance agreement and had been signed, over the course of years, Mr. Springman and I had occasion to talk on the phone, but not often. It would be reflected in the dockets if you have the dockets.
Okay. And those conversations that were infrequent, but with Mr. Springman, what were they about?
He had a few questions about what we had done on a couple of the provisions, and in one particular case, he thought that there was a typo, and the intent of the parties was, I can't exactly remember right now, but it was say X when he thought what we really intended was Y. So we were trying to figure out if we could maybe amend that just to make it clear.
Okay. And were you amenable to, I mean, if Mr. Springman in that conversation, if he said, listen, I'd like it to be amended, were you more than willing to have that amended or work on having that amended?
Yeah, I took his concerns to the people at Ornge, and I don't remember. It wasn't a significant issue. I don't recall anyone having a problem with it. Okay. I remember then speaking to Lynn Golding at Faskins, who I asked her about her recollection, and we thought actually in this particular case Mr. Springman was right, and that we should amend it. Okay.
Now, just in general, as a general practice, for this specific meeting, who arranged the meetings in general? The meetings with Mr. Springman, or the meeting with Mr. Springman and Mr. Georges? Who was, I guess, the...
Mr. Springman. Mr. Springman initiated those calls to me when he had questions about the performance agreement. Okay. And then and he also wanted to have a better, and he initiated the meeting on in December of 2009 on the bond transaction. Sure. They wanted to have a better understanding and grasp of it.
Did Mr. Apps ever set up any of the meetings?
With the
ministry side, that you were aware
of these of the people of the legal branch.
That's
people?
Right.
Not that I'm aware of.
Okay. Now, I'm going to switch gears a little bit and talk about salary disclosure issues.
Sure.
In terms of salary disclosure, when you were in-house counsel at Ornge, were you asked to give opinions on whether salary should be disclosed, or when it should be disclosed, or if it should be disclosed?
When I started, it was in June of 2011.
Yes.
And they had already. Their practice was that anybody outside who was employed outside the Ornge, the company Ornge proper, didn't disclose their salary. So I was an employee of Ornge Global Corporate Services, which was formerly Peel.
Sure.
So my salary didn't get disclosed. The issue came about in December when I don't know how it came about, but we were asked if we would agree to publicly disclose our salaries.
Who asked you to do that?
I think it came from the ministry.
And when was that?
In December. It was when all of the media stories started to take place.
I see.
And so we all agreed. I drafted up consents, and we all agreed to disclose our salaries.
Okay.
Except Dr. Mazza didn't want to consent to his.
Sure.
So the difficulty was that the rest of the executive team wanted to disclose their salaries. We knew that the Auditor General's report was coming out, and it had an aggregate number for executive salaries. We were concerned that if we all disclosed our salaries, then people would be able to do the math and determine what Dr. Mazza's salary was. Therefore, right. Indirectly, we would be disclosing his salary.
Right.
And we were concerned that because we didn't have his consent, we were putting the corporation at risk.
Okay. What about when you were not not in-house counsel, but when you were working as counsel for Faskins, working for Ornge? At that point, were you ever asked to give an opinion on whether or not salary should be disclosed?
I believe when I was talking to Ms. Sandals about back in 2003 when we were looking at the structuring, when we were looking at for-profit, not-for-profit charity, those sorts of things. We were also, I believe that was one element that they had asked us to look into. So if it's this corporation, is there, do you have to disclose your salary and all those sorts of things? And I had got a guy journal to come in and look at and give some advice on that. My recollection is his advice was the same as it was in 2007, except he didn't say, disclose, because there was no corporation at the time, right? So I believe he said, technically, you do not have to disclose if an employee that was employed by, an entity other than Ornge proper,
right,
wouldn't have to disclose. But with, but a regulation could be made very quickly to change that.
Okay.
So that was back in 2003. Then in 2007, when the entities were, we had incorporated Ornge.
Right.
Then in 2003, they gave a more detailed opinion, I believe, Mr. Journo and Ms. Golding.
Okay.
And I believe Ms. Golding testified as
She
to
did, that's
what
right.
their advice was.
At some point, Mr. Potter suggested that you had given him the opinion that he shouldn't, or he was exempt from disclosing his salary. Did you give him that opinion?
I had thought when I read that, the only time that Mr. Potter and I had that conversation was in December when we were all agreeing to consent. But we had received advice from the privacy lawyers at Faskins and Hicks Morley. Hicks Morley did all of the labor work for Ornge. We had received privacy advice from them that we had to be careful, given the Auditor General's report was supposed to come out with the aggregate number. We had to be careful if we all disclosed, we may be indirectly disclosing Dr. Mazza's salary. That was the only time Mr. Potter and I had that conversation.
That's fine. You indicated that you were employed with, or correct me if I'm wrong, Ornge Global Rotor. What was your involvement with that?
I wasn't employed by Ornge Global Rotor. I was employed by Ornge Global Corporate Services, Inc.
Okay.
Ornge Global Rotor, and I don't know if it still exists today, but that was the company that was supposed to run the rotor wing operation. That was the company that applied for a operating certificate to run the operation.
Sorry to interrupt you. What was your connection to that company?
Ornge Global Rotor?
Yes. Were you the administrator or the registered, where your name would have appeared on the registered office or the registered head or the administrator?
Did I, are you looking at incorporating documents?
Yes.
Yes. So oftentimes, if you're incorporating a company, it's more expedient for the lawyer to be noted as the incorporating director.
Sure.
And then the incorporating director would resign once the board was appointed. So it's quite usual. It's quite it's typical, and it's just done for expedience sake.
Okay. And then similarly for Ornge Global Brazil Holdings?
That's exactly what happened. I was the incorporating director, and then I was to resign when the new board came on, but nothing ever happened with that company. So.
Okay. You did indicate at one point in your testimony that if you had any concern regarding the helicopters in terms of the payments and the overpayments, that if you had any concerns, you would have brought them to the board if you had any misgivings, but you were clarified along the way that there was nothing to be worried about. Why would you have brought it to the board?
Well, I did. I had two instances where I did go to the board.
Yes.
Back in what had happened was we had come back from Christmas holiday.
Right.
And I had gotten a letter that was dated December of 2009. And it was a letter addressed to Mr. Potter from someone at Augusta Westland. And I was given the letter. And the letter, I don't know if that letter is before this committee. I was given the letter, and what the letter did was set out a prior agreement a prior agreement on what was going to be paid for the weight upgrades and all of the upgrades that we ended up doing. When I looked at that, I took it immediately to the board chair and Barry Pickford and gave them the letter. And
when
then
was that roughly?
that was in January of this year when I saw the letter. The letter had been over 2 years old.
Okay.
And that was the letter. If you will recall, I asked Mr. Potter if he had anything in writing to corroborate that he had negotiated a better deal. He said no. When I took that letter to Mr. Potter, I said to him, Rick, did you recognize this? And he said, yes. And he said, I forgot about that letter. And then I said, I asked you if you had anything like this. You said no. Yeah, I forgot about it. And then I said, and he said, I actually lost my copy. But there had been a number of other people in that office, apparently, which I had learned later, that had a copy of that letter. And the first time it was brought to my attention was January of 2012, right after we got back from Christmas holidays.
Okay.
At that point, I took it to the board. I then gave it to the interim vice president, Ron McCurley, and went from there.
Okay. In terms of any misgivings or any problems that you had, or if you had any concerns, you said that you'd go to the board, and here's an example, you went to the board. What I wanted to get at is that, was it a part of, do you feel that there's an obligation to inform the board of what was going on at Ornge, or if there's any concerns that you had at Ornge?
Absolutely. I would have, typically what I would have done, if I had any concerns, I would have gone to my managing partner first and chatted about that. And if we did then think that there was an issue, then we would have gone to the board.
Okay.
And, and depending on how they would react, then we would either continue on if there was a reasonable explanation, or we would have withdrawn from the file if we didn't agree with what they were doing.
Okay. Was there any obligation on your part, or did you see any obligation to inform the ministry if there's any concerns or any problems that arose?
I didn't see an obligation on my part.
Sure.
My part was to the client, the board, which had a fiduciary obligation to the company.
Okay. In terms of stakeholders in Ornge, would you agree with me that the primary stakeholder was the Ontario government?
Yes.
Okay. With respect to any of the, we've seen the debacle that Ornge is. Along the way, the Minister of Health has indicated that the performance agreement didn't provide enough oversight mechanism tools. We've heard many deputants have come forward and said the performance agreement had a slew of mechanisms in place that allowed the ministry to do various things to oversee Ornge, to provide the proper oversight. Can you comment on the performance agreement as someone who is working with Faskins and as someone who is in-house counsel? How did that performance agreement work, and did you think that there was sufficient oversight tools available?
I haven't reviewed the performance agreement in quite some time, but as far as I recall, there were audit
mechanisms,
for the ministry to audit their books and records. There were, I think there was a whole schedule at the back with reports that had to be filed with the ministry. There was Mr. Springman wanted a provision in there that if they were unhappy with the way the dispatch center was being run, then they could basically come in and take it over.
And when did Mr. Springman want that? I mean, how do you recall that one particular clause?
Oh, it went on for pages.
Okay, and how did that, come to your attention? Was that something that was amended and put in later on, or was that?
Oh, no, it was in there from the beginning.
From the beginning, okay. Okay. At any point in time, were you ever contacted by the ministry to work on amending anything in the performance agreement?
There were 2 later amendments, but I wasn't contacted by the ministry. I was contacted by Mr. Bloom, And
Is that Mr. Jacob Bloom?
yes,
Okay.
he had asked me to work on a couple of amendments, which were one was to provide, I think it was the critical care land transfer,
Sure.
and then they were doing something in Thunder Bay, and they were getting more funding, so we had to amend the agreements.
Okay. And what type of, there's been some suggestion that it would have been very difficult to amend the performance agreement, that there would have been a lot of stonewalling that would have been faced. That, if you can describe how that performance agreement amendment went, was there any sort of problems or any hiccups along the way?
It took some time.
Sure.
We went back and forth with drafts and whatnot. It doesn't happen overnight.
Right.
And just you go through drafts. Everybody comments. The lawyers put their 2 cents in. The clients. So I can't. I'd be speculating to say how long it took, but
Sure.
it wasn't a quick process.
Okay. I'm just going to read this one comment to you. Committee has been told that Ornge was given an option by Lynn Golding and Guy Giorno, critical of using the network of for-profits to hide salaries. As you've indicated, Lynn Golding and Guy Giorno were critical of it. And a different opinion from Alfred Apps was suggesting that this was appropriate. Do you have a personal opinion on those two different views?
Well, I think they resolved their views. When I got the 2 conflicting memos, I called a meeting with Ms. Golding and Mr. Apps. I don't think Ms. Golding recalled that, but I think she clarified that in her letter to the committee. And it was determined that Ms. Golding had the better view. And so Mr. Apps called the client and told them that there was this obviously conflicting view. They said, "Don't worry, we don't need the opinion in any event." So I don't think he ever finalized that memo. It remained in draft.
And your personal opinion on that?
Ms. Golding had the better view.
And you've used up your time now. We'll move to the government. Ms. Sandals?
Yes, thank you. And if we could go back to 2003, and if we, I guess, think from 2003 forward, we know from the work of the Auditor General and from prior testimony that eventually Faskens billed Ornge over $9 million for the work that they were doing. And given what we've been talking about, clearly that included lobbying or government relations in lawyer speak. If you look at page 3, in an entry that's dated January 22nd from Mr. Giorno, he references an office conference with Cynthia Hines and Lynn Golding to discuss government relations implications of structural and charitable status issues. And then if you go on down to page 5, another Guy Giorno docket. This one's dated February the 11th of 2003. It says follow up with client official race status of phase 2 of government relations plan. And then you go down to the bottom of page 5 and we see that Kevin McCarthy has been brought on the file, and it becomes clear with his billings that they are also government relations related billings. So just looking at those few docket entries as representative of dozens, you've got 3 well-connected conservatives. You've got the Minister of Health's wife, Ms. Golding. You've got the Premier's former Chief of Staff, Mr. Giorno. You've got Minister Flaherty's, who eventually became his current Chief of Staff, Mr. McCarthy, all at Ministry of Health expense, working on government relations. Agreed? That's what the dockets say, correct?
I don't think, as I can say, I don't think Ms. Golding was working on government relations. She was not working on government relations.
She's just in on the meetings directing them.
No, I don't think she was directing them. But I can't really recall, but I don't recall her being, like, I don't recall exactly what she was doing, but I
So
don't.
when Mr. Journo billed for a meeting to discuss government relations that she was at, that Mr. Journo was incorrect in his billing?
Where was that? Sorry.
That's the one on page 3, dated, about 4 or 5 down from the top. Mr. Journo, office conference with C. Hines and Lynn Golding to discuss government relations implications of structural and charitable status issue. Like, that seems to me pretty clear.
Well, she wasn't actively involved. As I said, Mr. Journo and Mr. McCarthy had registered as lobbyists.
She was just sort of there in the background.
She was, at this point, I think she was helping us trying to figure out the structure, so it was probably more of just an update or a briefing meeting. But I don't
I'm
recall
just reading what Mr. Journo wrote down.
You'll have to, I think you'd have to ask them, but I don't recall her being actively involved in that part of it.
So she's at least in meetings discussing this, and we've heard that Minister Clement effectively recused himself from the air ambulance file because his wife was counsel, and there would be a conflict of interest. We've got the Ministry of Health funding the air ambulance, funding Faskin's, wife is senior partner on the file. This is a circle that is not really quite kosher. If you turn to page 7 of the dockets, again an entry from Mr. Journo dated February the 17th, in which he has telephone calls to the minister's office, meeting with the minister. And we go down a couple of dockets to the 18th of February. Mr. Journo says, discussion with ministry official pre-briefing in advance of Thursday meeting with the minister. And below that, then we get a docket same day from Kevin McCarthy on the 18th, dated, that says, researched and drafted briefing materials for meeting with Minister Clement. So is it in fact true that Minister Clement was meeting with Faskin's lawyers, including Guy Journo, regarding the establishment of what eventually becomes Ornge?
I can't dispute what is in here. I don't recall that happening, but I don't know. So I don't think I'm the person to ask.
If it is as reflected in the docket, do you think it's appropriate that we've got Minister Clement meeting with Mr. Journo, his wife's firm, to discuss what's obviously a big account for his wife's firm?
I just do not recall that happening. I'm sorry.
So Ms. Golding never spoke to you about these meetings?
I don't recall that ever happening.
Okay. If we look at the docket on page 8, this is dated February 25, and it's actually your docket. And it says, telephone conversation with Hines+mazza, Ray Letters patent, and status of meetings with the minister. You've got a telephone conversation with Guy Journo, Ray same, and so there seems to be a conversation going on here between Mr. Journo and yourself and Mr. Mazza about meetings with the minister. So am I to read this then to say that there's another meeting with Minister Clement that Dr. Mazza was at?
I'm sorry. I don't know. I don't know.
So you've got no recollection around any of these conversations
That was a
about
lot-
minister
yeah.
meetings that are being set up with the minister. And I do recognize that it wasn't you that was setting up the meetings. It's clear from the record that it's Mr. Journo and Kevin McCarthy that are setting up the meetings. But you don't have no recollection of these discussions that you're docketed as being participating in.
No, I don't recall that. I'm sorry.
Let's look at another issue here. If we go down to page 17, the Red Tape Commission pops up in several entries, and lots of us remember the Red Tape Commission, which was advertised as getting the government out of the way of business. Mr. Justice O'Connor had some pretty negative things to say about the Red Tape Commission in relationship to Walkerton, but at any rate, if you look at page 17, there's an entry dated April 28th from Mr. Journo. He's preparing for and attending at meetings with ministry officials and preparing for and attending a meeting with 2 Red Tape Commission officials. He's booking a Red Tape Commission presentation. Then at page 18, we go on April the 30th. There's a telephone conference, again a Guy Journo entry, telephone conference with client vice president, Ray Legislative Reform, and meeting with Red Tape Commission.
I'm sorry, Ms. Sandals, which date are you on?
I'm on April the 30th on page 18, Guy Journo, about half a dozen entries down. Middle of his docket entry there, time card narrative there.
Telephone conversation with client vice president?
Ray Legislative Reform and meeting with Red Tape Commission. So I'm just wondering how on earth, if this is a simple matter of separating off the base hospital into a standalone corporation, how on earth this involves legislative change and the Red Tape Commission. I mean, this seems to have blown up out of all proportion to the simple matter of let's separate things.
That was the difficulty. It wasn't a separate matter, and you needed legislative reform in order for them to separate. So the Ambulance Act provides has a certain definition at the time, or had a certain definition at the time, for base hospital program, and it was a hospital, right? That ran. It was sort of a circular definition, but it was a hospital that has been, I believe, appointed by the minister to operate a base hospital program. Don't quote me on that, but it was something like that. So what needed to happen was Ornge, or the previous entity, was never going to be a hospital. So you needed to get an amendment to the Ambulance Act in order to provide that either a hospital or another entity appointed by the ministry or the Minister of Health to operate an air ambulance program. And I believe what had happened in 2005, they were waiting for that legislative change to occur. So now when you read the Ambulance Act, the definition of base hospital program had been amended, I believe, to say a hospital or a not-for-profit corporation or a non-share capital corporation that has been appointed by the minister. So when the minister actually, in 2005, appointed Ontario Air Ambulance Services Co. as the base hospital, it put in there that they had all of the powers of a base hospital under the Ambulance Act. So it wasn't a simple matter. It did require legislative change, and legislative change.
So I accept it needed legislative change. Mm-hmm. You're the lawyer. Mm-hmm. But what I don't get is why you need a whole lot of lobbyists being paid by the Ministry of Health instead of Sunnybrook having a conversation with the Ministry of Health. This seems an awfully circular way of figuring out what you need to do. I'm going to turn it over to my colleague.
And what time do I have, Chair?
minutes.
Oh, okay, thank you. Are you familiar with the this business that we've heard about the $1.2 million in loans to Dr. Mazza, which included a $500,000 loan by Orange Peel for assisting with the purchase of a home?
So you're asking what my involvement
No,
was?
are you aware of that issue?
Or am I aware that loans were made?
Yes.
Yes, I am.
All right. At page of the account book, page 921, there's an entry.
She doesn't have
Anyway, there's a time, one of the dockets, it's 2487, 3713, a docket by Lynn Golding, and it says, and I quote from the docket, quote, meeting with Bruce, re Foundation, and J. Smart, bracket, financial statements, and re 500K loan, bracket, not reflected as being...
Excuse me, would you like a copy of that?
Yeah.
Oh, I'm sorry.
Yes, please.
We'll get a copy made because... do you have an extra one there?
I've
what page it is.
921. Thank you, Chair. 921.
Ooh, right at the back. Sorry,
Okay.
I hope I didn't rip out the... 921 is it?
Okay.
Have you got it? It's the entry at 2487, 3713.
2487 3713.
Okay.
So, okay.
Just let me, meeting with Bruce Re Foundation and J. Smart, bracket, financial statements, and Re 500K loan, bracket, not reflected as being owed to GP, bracket, discussion with CH, and email exchange with Ron. So, question, I gather CH is you.
Mm-hmm. I assume so.
So, what was that meeting about?
Do we have a date? Because, well, it has to be this year because I assume Ron is Ron McCurley.
If you don't, it's fine.
So, I'm not certain, but Ms. Golding assisted with the wind-up of all of these for-profit corporations. I'm assuming, this docket is more recent because she helped the board wind down them all. So she was probably just trying to explain to the board what needed to happen in order to wind down.
All right, thank you. Did you have any involvement with the giving advice on the $1.2 million loan, including the $500,000 to Dr. Mazza for, homes and that sort of stuff?
There were two loans in 2010. There was one in 2010, and that was I wasn't with Ornge at the time, and I had gotten a call from Ms. Renzella saying that the board wanted to give a loan to Dr. Mazza, an employee loan, and wanted to take out a mortgage. And they had apparently called Hicks Morley because it was an employment matter, and Hicks is their labor counsel. Hicks said, if it's a mortgage involved, you better call Faskins. So I called somebody from our real estate department who took care of preparing the loan documents and the mortgage.
Did you offer any advice on the propriety
No, I didn't.
of that loan?
No, I
those
didn't.
owners. All right, thank you. We've heard from in the Auditor General's report and from the Auditor General that he had he was getting a lot of pushback when he went to Ornge and said, I'd like to see this, I'd like to see that, I'd like to see salaries, I'd like various statements from subsidiary companies and all of that. Did you offer any advice on the propriety of, I'll use the expression, pushing back against the Auditor General on his requests for this information?
No, I never tried. I never offered any advice on the propriety. When they asked me what they could give, I think it was our view, and not just my view, but it was our view that they were entitled to see all of the documents that related to Ornge and its subsidiaries. And I think the one thing that was in question, in my view, from what I can recall, was the shareholders agreement for that Ornge Global Management Inc. company, and there was personal and confidential information in there of the shareholders, and so we didn't think that it was appropriate to give that out.
Thank you. So Ms. Golding, Mr. Giorno, and Mr. McCarthy were billing Ornge from the period January 03 to October 03. Our tally comes to that's about 600 hours of work that they did. Can you, as the responsible partner, the billing partner, at that time, what was Ms. Golding's billing rate, roughly? What do you think it might have been at that time?
In 2003?
Mm-hmm.
I have no idea.
Could you get that information for us?
I can't, because I'm no longer with Faskins, but I'm sure if you spoke to the managing director of Faskins, he would give you that information. I understand they're trying to be cooperative.
Just as an experienced lawyer, you were there in 2003. You know their level of experience and their age and their call to the bar year and so on. And recognizing that it may be corrected when we hear from Faskins, but what would you guess their billing rate was? In what range?
Are you talking about Ms. Golding or Mr. Journo, or
all three, each of them? I mean, I know what a beginning lawyer bills at, and you know, and I know what a lawyer with 15 and 20 years experience bills at. So where in that range were these three?
In 2003, it really depends. I mean, Mr. Journo was new to the firm. He didn't sort of...
What year were you called to the bar?
93.
And what was your billing rate in 2003?
I think I brought mine. Mine was $380.
Were Ms. Golding, Ms. Giorno, and Mr. McCarthy, were they senior in you in terms of call to the bar?
Ms. Golding was. I don't know about Mr. Journo and Mr. McCarthy.
But anyway, a 10-year lawyer is $400 an hour.
We're out of time.
Thank you, Chair.
So we'll move to the opposition now. Mr. Klees.
Thank you. Can I just ask you, you tabled the aircraft purchase agreement. How did you come, you're no longer at Ornge, right?
I'm no longer at Ornge.
Or Faskins?
No, I'm not there anymore either.
How is it that you were able to provide us with a copy of this?
Well, in preparing for my testimony today, I asked Faskins if I could review some of the relevant documents that I thought you may ask me about today.
I see. Did you spend any time preparing with anyone at Faskins for this hearing?
I spent time going through the documents.
Did you have discussions with anyone at Faskins about what you would testify here?
What I would testify?
Mm-hmm.
We talked about what questions you might be interested in, so that I knew what I could help you with.
Was your statement reviewed by anyone at Faskins?
I'm sorry.
The statement that you prepared. The statement that you gave here.
Mm-hmm.
Did you review that with anyone at Faskins?
Yes.
Who?
Who?
Yes.
Stephen Hastings from our communications department.
And why would you do that?
To make sure it was accurate, and that I'm not at Faskins anymore. I can't speak for Faskins anymore, but I wanted to make sure that my recollection was the same of Faskins' recollection.
So who was it that you reviewed this with?
Stephen Hastings.
Stephen Hastings. And what is his role at Faskins?
He's a communications person.
Communications person. Is he a lawyer?
I'm not sure.
How long has he been at Faskins?
I don't know.
If you can speak up a bit, please, Mr. Klees. People are having difficulty hearing you.
I just want to make sure that you're listening. So you reviewed, you're a lawyer. We weren't quite frankly interested in having a communications piece here. We wanted some facts, and we assumed that we would get those from you.
Mm-hmm.
I find it quite interesting that in your preparation, I could understand if you sat down with Lynn Golding.
Yeah.
I could understand if you sat down with...
Well, I did sit down with Lynn.
Oh, you did with her as
yes.
well?
Yeah.
And who else?
It was Lynn Golding and Lisa Marcuzzi.
And what is she?
She's a lawyer, and she worked on the file as well. There were a number of people working on this file.
Oh, I'm sure.
All through the period of time, and I wanted to, if I was speaking on behalf of Faskins, I wanted to make sure that my recollection was the same as theirs, because they haven't had a chance to come and speak about this particular
So
matter.
you've had an opportunity to collaborate your presentation here with a number of people. The communications person at Faskins.
We didn't collaborate. I wanted to make sure that that what I was saying in there, they didn't disagree with.
And what if they did disagree with it?
Well, I can't speak for Faskins anymore, but at the time that this was going on, I was at Faskins. So I wanted to make sure that I was making an accurate reflection of my recollection and not saying anything incorrect. There were so many of us involved in the file, I wanted to ensure that I was giving you the proper information.
You understand what's puzzling to me?
Not particularly.
Well, no, but you have to go to Faskins and speak with their communications person and some other folks.
He was just one of the people. I mean,
But why was he there?
It was Lynn, it was Lisa, and we went through it.
So there were just the three people there. There was Lynn Golding.
And I believe, and their counsel was there.
And their counsel?
Mm-hmm.
Explain that.
Well, Faskins' counsel,
And who was that?
Gavin McKenzie.
Okay, so now this is getting even more interesting. So you had a meeting with three individuals from Faskins, two of them lawyers, one of them a communications person. And they each had counsel attending with them. Is that right? That's what you're saying? Faskins' counsel.
They didn't each have counsel, no.
So there was one counsel for the three of them.
Yes.
And what was the purpose of them having counsel there? What did the counsel's role, or what was the counsel's role in this discussion?
You just listened to, and he reviewed the statement as well.
And so the product that we have here that you presented is the result of vetting that took place. It's the result of a collaboration between counsel to Faskin, two lawyers at Faskin, a communications person at Faskin, and I'm assuming that with all of that effort, there isn't anything in your statement that would have contradicted any other testimony from Faskin.
Number one, I'm under oath. Everything in this statement is accurate and completely correct. Number two, I don't believe anybody from Faskins has given testimony on this, the things that I thought you would be particularly interested in knowing, and that our story had not been heard. We had been told one thing, and we were under the impression that our advice had been followed. And what instead has been happening is people have come before this committee and either have said and had said certain things that were not true.
Can you give
And
us an
so
example?
it was very important for us to ensure that our advice that we actually gave, and this should be very helpful to you, Mr. Klees.
Well, in that
Because
case, I'd
this-
like the rest of
this-
it.
this
Okay,
is the truth.
You've given us a partial document.
A partial document
Well,
of what?
there's the aircraft purchase agreement certainly isn't all here, is it?
Oh, no, but I had assumed that you had the entire agreement.
No, we don't.
And so I took excerpts of what I thought you would be most interested in, and that would help to help you understand the issues at the time when we were
Sure.
first asked about this.
It would be
But I
very-
had understood that you had the full agreement.
No, we don't.
Oh, I thought you had referred to it.
So could you arrange to get that for us, please?
I can't speak to Faskins, but again, I know they're cooperative, and they would be happy to give you that agreement.
Okay, appreciate that.
I assume they would, so you just have to ask the managing partner.
Thank you.
You're welcome.
As the counsel for Ornge, you are intimately familiar, no doubt, with all of the incorporation documents for the various companies. Is that right?
I didn't incorporate all of them. A lot of the documents were incorporated by clerks, but pretty much I know I have just referring to the corporate chart here. I don't know if you all have seen it, but
No, we'd love to get a copy of that. And so you actually, clerks may have done the documentation, but you oversaw. So you're familiar with all of the companies.
I'm not familiar with all of the companies. They were various people had incorporated them. I was more involved in the incorporation of the earlier companies. So Ornge, for example, I had prepared the letters patent, the objects, and the bylaws.
Okay, let's talk about Ornge then. That'll narrow it down. Do you recall how the board of directors was appointed?
When I was at Ornge doing this secondment in 2005, I had drafted the objects up, and I had drafted the bylaws, and I was given a number of bios of the people, the prospective board members. I think Dr. Mazza had been interviewing people for the positions, and had a board that he had, a list of prospective board members. I then took those bios, the bylaws, the draft bylaws, and the draft objects, and someone, I can't remember, it was myself or Mr. Bloom, sent them to the ministry for approval.
Okay, and so the ministry approved the board of directors?
I don't know if they were asking for approval per se, but they didn't raise any objection to any of the people who were on the board.
But the board was vetted by the minister's office, is
that's
that
my
right?
recollection.
Do you know if any nominations were made from the minister's office for that board of directors?
No, the bylaws didn't. The bylaws didn't. They didn't allow for that. It was a not-for-profit company, which was, there was no ministry appointees. If that's what you're asking.
No. I'm just asking if
yeah.
there were any nominations from the minister's office.
No.
Okay.
No.
And so you got the names back. What happened then? How did this all get? How did I become a member of the board of directors? It was kind of a self-baptism, was it?
No, that's not quite how it works. There was a company that had been started. It was Ontario Air Ambulance Services Co., and there was an interim board that was comprised of members of Sunnybrook. And so once the performance agreement was signed, and then once there was no objection by the ministry of the proposed board members, then that board resigned and elected the new people in their capacity as members. They elected those new people as members of the board of directors.
Okay. Do you recall, I'm assuming that those board meetings took place in a very organized way. Who kept the minutes for those board meetings?
I don't remember who kept the earlier minutes. In about 2008 or something, they decided they needed a corporate secretary, but I think they had like various executive assistants take the minutes of those meetings.
Who became the corporate secretary?
There were two. One's name was, the first one was Melinda Moore, and the second one was unfortunately just terminated in January. Her name was Lynn Taylor.
Okay, I assume that as the in-house counsel, that you kept the books or the records of those minutes. Is that right?
No, that's the job of the corporate secretary.
Do you recall, was director's liability insurance ever applied for or put in place for the directors?
Yes.
And what was the liability limit of that?
Pardon me?
What was the liability limits under that policy?
I think it morphed. So when they, I shouldn't say it morphed, but initially, I think that there was D&O insurance under one, it was like an umbrella policy from HEROC. It was the Health Hospitals Insurance Reciprocal of Canada. But then I think as various things were going and the organization grew, they got their D&O insurance from I want to say Marsh, but I think the limit changed and it increased toward, as we were getting into this structure, but I can't recall the exact.
Okay, but it was in place.
It was in place.
Do you recall, were bylaws ever passed to provide indemnification of the directors internally?
The actual bylaw of Ornge provides for indemnification of directors in the absence of certain
and
activity.
do you recall, was that the case for all of the several companies then that were subsequently incorporated?
I just recall there being, there could have been, but I only know of D&O insurance for Ornge Peel, and that Ornge Global Inc. entity. There could have been, they might have, I'm thinking that they might have had an umbrella policy where it covered all of the organizations, but I just remember before I left the organization having this conversation with the new board that has just been appointed, and they, as to D&O insurance, and we arranged a Marsh to come in and speak to the new board about D&O insurance.
Given these several questionable financial transactions that took place, your opinion in terms of potential liability for directors of these companies, if you were a director of any of these companies, would that be of concern to you?
You're assuming that there's an investigation going on, and they're going to make the determination of what's occurred. It really depends on what they find out. I would, before all of this happened.
Caution us not to get talking too much about investigations.
Yeah. I just, Mr. Klees, I can't. I don't think I'm not a director. I can't really speak to it.
Have you been a shareholder of any of the several organizations?
No.
You were never kind of led into the inner circle?
No.
Okay. Are you glad about that now?
Pardon?
Are you pleased about that now?
My life has been through enough change.
I'd like to just, how much time do I have?
3 minutes and 8 seconds.
Don Guy pulled back his last invoice. In all the time that you've been in business, you're professional, Have you ever experienced a consultant withdrawing a bill for consulting services?
I don't think I knew that he had done that.
No, he did that. Do you have any sense of why he might have done that?
No, I don't. I don't know Mr. Guy. I've never met Mr. Guy. I've had no interaction with Mr. Guy.
It was just around the time when there was some media activity around Ornge, and for some reason, Mr. Guy decided to withdraw his invoice, and I just thought maybe you would know why that took place.
No, I wasn't even aware of that retainer of Mr. Guy. I had heard about it actually through someone at Faskin's asking me about an invoice that they had received, but I didn't even know at the time that he had been retained.
Okay. Do you know who introduced Alfred Apps to Ornge?
That was me.
That was you?
Yeah. It was back in 2007 when Maria Renzella came to me and said, Dr. Mazza wants to buy aircraft. He doesn't have the money. How do we do that? And I went to the firm and I looked for an aircraft financing expert. I sent out a broadcast memo and to see if there was any expertise within the firm. One gentleman came forward, but he said that he didn't really seem to be the kind of expertise we were looking for. So I started looking through the firm website to see if there was anybody in the firm who could, help. And he was noted as a structured finance expert. And I called him. Prior to that time, I didn't know him. We hadn't worked together. And I called him and I said, "This is what this client would like to do. Do you have any? You think you can help them?" And he got very excited and he said, "Absolutely." So that was me, but I didn't know him before.
So you made his day. You gave him a call, and look what happened.
Look what happened.
Thank you very much.
Thank you, and you have 5 minutes each for one more round. We'll move to the NDP. Ms. Jellivis.
Quickly, I have read some of the papers that you have written in health law in Canada. Some of them actually I was quite happy when you wrote about Bill 179, a missed opportunity for collaborative care in Ontario. I also saw that you did this with your articling students. Anyway, that's something that I was interested in. I was pleased to read that. I also saw that you co-author a paper with Mr. Stevie, and I was wondering, what is your relationship with Jameson Stevie?
Jameson, I believe he was a young associate. That was probably back in 2003, 2004. I think that was when the Romanoff report came out, and we worked on a publication together. But Jameson left the firm years ago. I haven't seen him, nor have I spoken to him since he left the firm.
Okay, so you worked with him on that paper, and then you never saw him again?
Yeah, he was a member of our health law group. Yeah, but I haven't talked to him. I haven't seen him. So he's a very nice man.
So when was the last time you saw or talked to Jameson?
Probably when he left the firm. Yeah.
So that's about 2003?
Well, was it 2003? If that's when he left the firm, then it would be 2003.
Okay.
Yeah.
Okay. All right. So, coming back to the working with Mr. Apps, Mr. Apps was the expert for structure, financial expert, and he went on to design this corporate structure for Ornge. In your view of what was created, why was such a complex structure created?
My understanding is there was a need for most of these companies. For example, Mr. Apps, when we started this, there was just Ornge, and then there was Orange Peel, and there was the Foundation and J Smarts. It was a relatively, I think there was an Orange Co in there somewhere, but it was a relatively straightforward structure. But at the time when they were looking to purchase the aircraft and do it by way of a bond, Mr. Apps had said that investors don't want to invest in subsidiaries of charities, and that you normally do this through a partnership or a trust. And so then that's when OIT was formed, and then it went from there. And then when there was the for-profit business, they were looking for an entity or a structure, which was a limited partnership that would be investable, like that would be attractive to investors. And I don't know much about this, but right there with the limited partnership, you have three entities. You have the actual partnership, and then you have your limited partner and your general partner. So you've already have three there. So
okay, so the structure is there, as complex as it is. Some people say that it evolved under the guidance of Mr. Apps to be what it was before it got all rolled back. None of them ever did anything to be in business. I mean, sure, there was an issue offering, money came. The only business transaction that we saw was really the real estate, where the not-for-profit pays the for-profit more than what the for-profit bought the real estates for. And then there was the marketing service agreement, where again the not-for-profit has given a whole bunch of money that comes back to the for-profit to go someplace else. Like you were there, you saw all that. There was never a red flag raised.
It seemed to me at the time that there was a need for these companies, and when you're trying to get investors in, that's not my area of expertise. I'm not a structured finance expert. That's completely beyond my area of expertise. I actually I wasn't involved in the credit lease transaction. I don't know a lot about the credit lease transaction. I had a hard time following it and understanding it. I wasn't involved in that, so. But insofar as I was aware, every company had its purpose. And
you've worked.
And we are out of time here, so we'll move to the government. You have 5 minutes. Would like to go,
Yeah.
Mr. Zimmer.
Thank you, Chair. 5 minutes for the Liberal side, right? Yes. All right. This morning you gave what I thought was a very moving statement about the sort of general overview, what went wrong, how this all happened, and you spoke about some characteristics of Dr. Mazza's personality and ambition and so forth. I was quite taken by that. So my question this afternoon is, you're a lawyer of 21 years experience, obviously very skilled and talented at what you do. You've been through some difficult times, or difficult pressures the last year or so, months or so. As you did this morning, offered that general overview of what the problem was with Dr. Mazza and his ambition and his personality. In hindsight now, what lessons have you learned from this exercise, both as a lawyer, and what advice would you offer to a younger lawyer about to start his or her career in a position, something like yours, who might fall into a similar sort of scenario like Ornge in the next couple of years? What lessons did you learn? What advice would you offer to that younger lawyer who wants to avoid this mess?
There's always lessons to be learned.
Louder.
There are always lessons to be learned, and there's definitely room for improvement. Looking back, I think we could have done a better job at persuading him to slow down to move more deliberately in what he was doing in trying to expand the business. At the time, I think we all thought that we were doing what we could to try and slow him down, but sometimes they took our advice and sometimes they didn't. But I guess the lesson learned is we probably should have tried to do more to persuade him to move more slowly and more deliberately.
Thank you.
Yeah. As we think about all the money that flowed through your firm, why, when you get right down to it, why were Mr. Journo and Mr. McCarthy essentially spending so much government money to lobby their own Harris Eves government?
I don't know, Ms. Sandals.
How can you possibly justify that tens of thousands of dollars from the Ontario Ministry of Health are being handed over to Faskins so that Journo and McCarthy, Golding can effectively take government money to turn around and lobby the government where they've all got such close ties to the government?
Well, they were, I don't know. They tried to do it the proper way. They registered. They knew that they registered for lobbying. They knew that legislative reform was needed, and that could take some time. And that's all I can tell you.
So if you're properly registered, that makes it okay to take money from the government, and to, particularly in the case of Miss Golding, and I know you've said that she wasn't always directly involved, but she was certainly involved in some of the conversations, to take money from the Ministry of Health when her husband is the Minister of Health, cycle that through the law firm, and have that pop up the other end of a very lucrative contract. It seems a very unusual relationship.
As I said, I'm not sure how that all of that was paid for, and I don't want to speculate. I think that would better be answered by someone in finance.
Well, I think we can be sure it wasn't coming out of Dr. Mazza's personal pocket, so it had to be coming out of ministry funding.
We are out of time there. You have 5 minutes left for the opposition. Mr. Klees.
Thank you. We left off with Alf Apps. I'd like to just get back to him. So obviously your introduction meant a great deal to Mr. Apps. He must have been very grateful to you for that, and no doubt you became good friends. He had many talents. Did you say we've
become good friends?
I would think so.
We're not close, Mr. Apps and I. Mr. Apps and I.
Mr. Apps did a lot of contract work, I'm assuming, with all of these various details of his work then subsequently. There would have been a number of meetings that he had with government ministers' offices and so on to explain things and so on. Do you recall Mr. Apps making arrangements for presentations to ministers and so on?
I understood, just because I go through the bills.
Yes.
He was arranging meetings with people from the government.
Yes.
When we discussed it, he said, and by the way, I don't have to register because he said, because I am, just want to get the words right, because I am not asking the government for anything. I'm only providing them with information, and I'm telling them a good news story.
And when did you have that conversation with him?
Well, that would have been in the fall of 2010, when these,
Sure.
meetings and things were being arranged.
Did you find it strange that he would go out of his way to say, I don't have to register as a lobbyist?
No, no. I mean, no. I didn't. I don't know Mr. Klees whether I had asked him, well, have you registered? I know that he was looking into registering. I think we had had that conversation before. And then he had just followed up to say, I don't have to, because in my view, I'm not asking for anything. I'm just telling a good news story.
Mr. Apps is very politically active, and I understand that on occasion he would host little fundraising receptions at the firm. Did you ever attend any of those?
No.
But you knew that they were taking place? You would hear about them?
I don't know about all. Is there a specific one? I'm not sure.
No, but are you aware that he did that?
That he had.
That he held fundraising receptions there?
Yeah, vaguely.
Okay.
Yeah, I'm not a political
You're not a partisan
person.
type person.
No, I'm not.
Okay. And in retrospect, is there anything that you would have, on a specific case, that you would have advised the board of directors that was going on about which you had concern?
If I would have had an inkling, believe me, I wouldn't. I would have gone to my managing partner. As I said, I would have gone to the board. The toll this has had, it's not, no client is worth it. If there was any indication, I would have followed my obligations and responsibilities of the Law Society, and I would have, done what I needed to do. Right?
You would have.
I would have.
There were occasions when you didn't.
I would have if I had an inkling.
I see. Thank you.
Thank you.
And thank you very much. Thank you for your coming before the committee this afternoon. The committee is adjourned.